Good morning, players. So the Michigan Supreme Court has rejected a bid by the Michigan Secretary of State to remove Frumpy Dump from the 2024 ballot. Y'all go ahead and grab your tea and have a seat. Let's get into it. So the Michigan Supreme Court has rejected an attempt to remove Stinkmeaner from the state's primary ballot under the 14th Amendment's insurrection ban. Now, this lawsuit is a bit different from the one we've seen in Colorado because it was actually brought by the Michigan Secretary of State. So they basically ruled that the Secretary of State lacks the legal authority to remove him from the ballot. So the Michigan State Appeals Court had already ruled that the Michigan Secretary of State does not have the legal authority to remove Frumpy Dump from the ballot. So the Michigan Supreme Court just agreed with the lower court's decision. So the Michigan Supreme Court basically said that they were not persuaded that the questions presented should be reviewed by the Supreme Court. Now, Tuesday's ruling does leave open the possibility that the plaintiffs could renew their efforts for the general election if Frumpy Dump becomes the Republican nominee, which polling indicates is very likely. So this decision has a legal victory for Frumpy Dump and his lawyers as they try to get rid of these lawsuits across the country using the 14th Amendment. Frumpy Dump's Cracker Jack Box legal team has shockingly successfully defended him in cases filed in places across the country, including Minnesota, where the state's high court tossed a 14th Amendment challenge last month. But in Colorado, the state Supreme Court last week was the first to take the extraordinary step of ordering Frumpy Dump's name off the ballot. So again, this challenge was a bit different from the others that we have saw. The Michigan Supreme Court basically ruled that the Secretary of State does not have the legal authority to remove Frumpy Dump from the ballot. But the one in Colorado made two determinations: that January 6th was indeed an insurrection, and also that Frumpy Dump was an official officer of the United States. Now, this challenge was very different. So we'll just have to wait to see what comes out in the Washington arrangement. Frumpy Dump has not appealed Colorado's decision as of yet, but it's on hold until January 4th. So we can expect that any day now, and it will go to the highest court in the land, the United States Supreme Court. All right, players. Oh, and I can't forget to show you what Frumpy Dump had to say, honey. He's as happy as a flea on a dog's ass. However, I don't feel like it's happiness because, again, they left this open that this challenge could be presented again correctly. They basically just said that the Secretary of State does not have the authority to remove Frumpy Dump from the ballot. It didn't even take up the challenge of whether it was an insurrection or whether he was an officer of the United States. So it's going to be very interesting to see if they refile this. I'm pretty sure they will. All right, players, put your thoughts in the comments. This is Double D Mova reporting for the Black Accurate News.